In 2026, insolvencies in the UK are at a 14-year high and business owners like you are getting squeezed from every angle. But you know what the real problem is? Most directors don't understand the proper way to close an insolvent company until it's too late. Now, if you get it wrong, you can end up personally liable for company debts, and those risks are very, very real. But if you understand the process, you can prepare for, and most importantly, beware of any risks that you're going to face before you make any decisions. So, what does insolvent actually really mean? Well, let's get it straight. Insolvency isn't about how you feel, it's about what the numbers say. So, you've got a number of different tests. First one is a cash flow test. Can you pay your debts when they fall due? And if you can't pay your debts when they fall due, you're insolvent. If you're on a time to pay arrangement, you're insolvent. If you're robbing Peter to pay Paul, you're insolvent. The second thing is a balance sheet test. If you total up all your liabilities and they are more than your assets, you fail the balance sheet test as well. Now, if either of these apply, legally your business is insolvent and your duties as a director, they change. You now have got to prioritise creditors, not yourself. And this is where lots of directors go wrong, because they keep trading hoping to fix it. And when the law says you should stop and seek advice. Now, there's lots of people who say, well, you're insolvent, you need to appoint a liquidator. That's not strictly true, okay? You've got to look at it and go, right, I'm insolvent. Have I got any reasonable hope of recovering and getting back on a firm financial footing? And if the answer is no, then you've got to be looking at some insolvency options. Now, if you fail any of those tests, I'm going to call it out early. Go to the comment section, click on that link, put your details in. One of my team will call you today. We will run through your options. We will not frighten the life out of you. We will give you some honest advice in plain English. Now, if you are insolvent and you want to close that company down, really there are two main ways to close an insolvent company in the UK. You've got a creditors voluntary liquidation, CVL for short, and that's where you take control and you close it voluntarily. It's your decision. And you've got a compulsory liquidation, and that's where a creditor will force you into liquidation through the court process. Now let's walk through both. And I'm going to talk to you by one protects you and the other can destroy you. So option one is a creditor's voluntary liquidation. This is like a general liquidation. And it's where you, the director, have become insolvent and you choose to close the company down voluntarily because you know it can't pay its debts when they fall due and you know you've got no hope of it recovering. You are being responsible as a director. You are taking your director's fiduciary duties seriously. Now, the whole process has to be done by a licensed insolvency practitioner, okay? It is responsible. It is the legal route for insolvency companies that have got no hope of getting back on track. And if it's done properly, it can protect you personally, okay? Now, there's a process to this. First is, you've got to find an insolvency practitioner. By the way, I'm not an insolvency practitioner. The reason why I do these videos and they're so successful is I have been exactly where you were 10 years ago. I had to liquidate a business and it was an awful experience, very frightening, and I realized there was no information designed at educating directors. It was all very confusing. But you find an insolvency practitioner. You have a board meeting, and that's where the directors agree the company can't continue, and you appoint that insolvency practitioner, and they act as something called a liquidator. Now, you've got to bear in mind, 75% of shareholders need to approve the resolution to appoint a liquidator. Then, creditors are notified, okay? So all your creditors are served notice that your business is going through a voluntary liquidation. You set a creditors meeting, and at that creditors meeting, the insolvency practitioner or liquidator, they're the same thing, they take control, they take the appointment. And their job is to try and sell some company assets to realise some money to pay back creditors. And they're also going to file a report on your conduct. And this is what happens to you. The minute the insolvency practitioner takes the appointment and they become the appointed liquidator, you lose control. But you need to remain involved. You've got to comply with requests from the insolvency practitioner. You've got to help them. The liquidator is going to review your conduct, but that is standard. It happens in every insolvency in the UK. And you know what? If you've acted responsibly, you're protected. You've got nothing to worry about. And in 99% of cases, you can start another company if you want to, unless you get disqualified, okay? Now, there are some issues going into insolvency that you have got to be aware of, okay? Now, issue number one is you've got personal guarantees that you're going to have to deal with. Remember, a personal guarantee is going to follow you round. Once you go through a voluntary liquidation, that guarantee will pierce the veil of incorporation and come to you for the money. Now, 99% of cases, you'll be able to get deals done with PGs, okay? It's really important that you understand how you're going to deal with PGs really before you hit the button on any insolvency. Overdrawn directors' loan accounts. Remember, this is a big problem that can't be avoided, but you can certainly understand it. It's where you owe the company money, and nearly all directors who take a combination of salary and dividends have overdrawn directors' loan accounts at the point of liquidation. And the reason is, say this last year you've become insolvent, you can't pay HMRC, can't pay suppliers, but you've continued to take £1,000 a month salary and the rest as dividends. Well, I've got a surprise for you. Those dividends in an insolvency will get reclassified as illegal dividends. Now, you're not going to prison for an overdrawn director's loan account, but you are going to be landed with a hefty bill by the insolvency practitioner. They are going to come to you to ask you to pay that back into the company, okay? Now, if you're worried about overdrawn director's loan accounts, and you should be, I want you to pick the phone up to us. We will help you understand your position and give you some options of how it might be dealt with post-insolvency. In most cases, you can get deals done on overdrawn director's loan accounts depending on your personal situation. If you're in a £1 million pad with no mortgage, it's going to be a lot more difficult to do a deal than you are if you're in rented accommodation on universal credit. But the key thing is you've got to be prepared. Now, let's move on to compulsory liquidation. Now, this is when creditors, and mainly it's HMRC, but any of your creditors can do this. They're trying to get the money in, but they lose patience and they file a winding up petition in court. Now, they're basically saying to court, this company needs winding up because it can't pay its debts when they fall due. If you don't pay the winding up petition or pay the amounts on the winding up petition before the court, the company is liquidated compulsory and you lose control. Now, the consequences of a winding up petition and being compulsory liquidated, well, first of all, the minute that petition becomes advertised, your bank account will get frozen and it's going to be impossible to trade with no bank account. The official receiver is going to be appointed. They are going to go give a full investigation into your conduct. And the first thing they're going to angle at you is, well, you as a director, when you knew you was insolvent, you should have really done this voluntarily. So it's very easy to say that you've behaved improperly just by the very nature that you've let the company get wound up. I mean, in my experience, the consequences of compulsory liquidation are always worse than voluntary. Now, if they find anything wrong in your conduct, they can and they will pursue you. And what I believe is the difference between the official receiver and a normal insolvency practitioner is an insolvency practitioner's got to have a degree of commerciality about them. You know, they are businesses that have got to make a profit at the end of the day. Whereas the official receiver is a public body and they could spend 100 grand recovering 10,000. Like, you've got to avoid a compulsory liquidation if you can do. Now, in 2026, everything's moving faster. Petitions are getting to petition stage quicker than ever before. HMRC are able to dip into your bank account. There's more enforcement agents coming out trying to take people's assets. Everything's sped up, and what used to take bloody 12 months is now taking 12 weeks. So you have got to be prepared. This creditor pressure is real. People are circling, and you've got to choose voluntary over compulsory. One is strategic and the other one is absolute chaos. Now, what's going to happen during these processes? Well, remember, a liquidator is going to try and sell assets, vehicles, stock, websites. They're going to try and recover in overdrawn directors' loan accounts that you owe, and it's to repay creditors. Now, remember, if you're thinking about selling assets before you appoint an insolvency practitioner, you've got to make sure that you are selling them for a fair market value. Now, once the insolvency practitioner is appointed and they've realised some funds for creditors, what they do is they pay them in order of importance. And the first person is a secured creditor, someone who has a charge or a debenture against the company. Second is a preferential creditor, HMRC fall under that. And then you've got unsecured creditors, so that's generally your suppliers, your landlord, your energy bills, etc., etc. Now, most of the time, HMRC, if there's some money left, will get something and they'll get paid ahead of your creditors, okay? Your general suppliers. Now, staff, remember, they can claim redundancy. They can claim redundancy if they've been there over 2 years. They can claim unpaid holidays that have been accrued and not taken. They can even claim unpaid wages and actually notice pay in lieu of not being given the correct notice. And they can claim those through the redundancy payment services. Now, sometimes, only sometimes, a director may also qualify for redundancy as well, but it's a lot more difficult when you're a director. Now, there are a lot of risks associated that I touched on earlier. I want to go over them again. Directors' loan accounts, they are going to be repayable personally if you've taken more money out of the company than it can afford to pay you. You've got to have a plan in place with your directors' loan accounts. And what we believe here at Director First is we'll help educate you. Have you got an overdrawn director's loan account? What is it up to date? What is your personal asset position? And what type of deal could you get done with an insolvency practitioner post liquidation? Remember, an IP can't commit to a deal before they've become appointed. They generally don't have the authority to do so. But you know what? A good one will help you. They'll help you understand what a likely settlement might look like, and we will help you with that. Obviously, personal guarantees, these are going to follow you around post liquidation. You've got to be careful of wrongful and reckless trading. So if you are insolvent, you've got no hope of recovery, but you're going out there racking up supplier bills, you're building up more arrears to HMRC, you're taking money from customers and you know you're never going to be able to fulfill the job. This is something that's going to get you in serious trouble once you end up in insolvency. And there's also a thing called preference payments. So once you become insolvent, you've got to be really careful who you pay. You can't pay certain creditors over another one because you will be treating them in preference to everyone else. And what can happen is either the insolvency practitioner can go for the creditor to ask for the money back, but most likely they'll set it aside and make you personally liable for it. So what is the protection to all this? Well, the key thing is acting early. Document everything. Take advice early, okay? The insolvency service is a pretty strict thing, but they are fair with directors who are transparent. And you can recover from insolvency. Most people do. It's the directors who don't act. They try and hide things. They delay or they lie. They're the ones that tend to get punished. So closing an insolvent limited company in the UK in 2026 looks like this. Accept insolvency. If you cannot recover, accept it, don't deny it. Choose voluntary liquidation over compulsory liquidation every day of the week. Choose the right insolvency practitioner. We can help you with that and work with them, not against them. And protect yourself by acting fast and staying honest. Liquidation is not failure, it is feedback. It's how you close one chapter properly so you can start again the right way. If you're a UK director and your company can't pay its debts, don't wait for HMRC or the courts to decide your fate. Contact Director First today. We will help understand your risks, we'll help you protect your position as much as possible, and we will help you close the company the right way. Now, if you've enjoyed this video, okay, and you want more, Go on here. This next video is about will you be made for personally liable for company debts, updated for 2026. Go on there. I'm going to tell you all the areas where you might get made personally liable and things you can do to try and protect yourself. Thanks for your time. Chris Worden, Director First.